But it's my job today to introduce to you our luncheon speaker. I'm very excited about the fact that Patti Williams from the Department of Public Instruction is here with us today, and she will be discussing a special education legal update for us. So she has a great session planned for us. All of you should have a handout in front of you. If you don't, if you want to raise your hand or take one from the next place, that would be absolutely fine. Patti Williams is a consultant with the Department of Public Instruction who works in the area of special ed procedural compliance. She is the coordinator for the state IDEA complaint process and is the liaison to the due process hearing system. She is a former Wisconsin Department of Public Instruction liaison to the Wisconsin Special Ed Mediation System. It's my pleasure today to introduce to you Patti Williams.
Thank you, Bonnie. Thank you. So what I thought I would do for the presentation is just look at guidance, complaints, due process decisions that have come out for the 2014-2015 school year. And sort of I put a little bit of emphasis on topics that might be coming up now for you, like ESY or graduation and that sort of thing. So that's what I thought I'd do. Can everybody hear me okay? All right, good. So I'm going to first cover guidance that we've received from OSEP, and you can just follow your outline that everybody should have. And then I'm going to look at IDEA complaint decisions, and then I'm going to look at just one due process decision, and then finally I'm going to just cover a few resources that have been developed by the department this year and just sort of tell you where you can find those. So the first OSEP letter that I'm going to talk about is called the Letter to Bowes, and I'm sure I won't pronounce these names correctly, but I'll give it a try. In this letter, they addressed independent educational evaluations, okay, so or IEEs. As you probably know, a parent has the right to request an IEE if the parent disagrees with a special education evaluation. So that's a right they have under federal special education law. If a parent requests an IEE, then the law provides that the district must either file a due process hearing to explain and show that their evaluation was reasonable, or ensure that this IEE is provided to the parent at public expense. So what this letter addresses, and the question asked in this letter, is if a parent can request an IEE in an area that wasn't assessed by the school district. Okay, so let's say that the district evaluated the child in the areas of EBD and OHI, but the parent thought that the child should also be evaluated in speech and language. Okay? So what this letter says is that the parent could ask for that assessment in the area of speech and language, even though it wasn't evaluated by the district in their evaluation. I think the reasoning of OSEP is that when an evaluation is done for a student, it must be comprehensive. And so if there's a feeling that something was left out, then they can assess that through the IEE process. So that's the first letter. The second letter is a Dear Colleague letter that OSEP put out to the field, and it focuses attention on the educational needs of students with disabilities who are in correctional facilities. OSEP looked at the data nationwide, didn't particularly look at Wisconsin, but nationwide, and they were concerned that students with disabilities that are in correctional facilities are not receiving the services that they are entitled to. So that's why they put out this Dear Colleague letter to serve as a reminder. They wanted to remind the field that IDEA protections continue to apply to students with disabilities who are incarcerated, and that continuing to provide FAPE to these students also helps them re-entry into schools, their community, their home when they're done. So that there's a real need to provide FAPE while they're there, because it also helps them transition back when they're done. So the guidance covers a lot of different topics, and I would encourage you to read it. It covers child fine responsibilities. It requires a requirement to provide FAPE. It looks at LRE. And with regard to the child find responsibilities, the letter states that school districts must work with those individuals who are likely to come in contact with students in the juvenile justice system. So that might be intake staff, social workers, and probation officers. So they're encouraging school districts to have contacts with these people to help identify students that are in their facilities that may be in need of special education. OSIP also stated that efforts should be made to coordinate between a school district and a correctional facility to avoid the interruption of FAPE. This would include transferring records as expeditiously as possible and no more than within 5 working days. You don't want to exceed that. That's under our state law. And who is responsible for providing FAPE depends on the situation. So when a student resides in a jail, it's a school district where the jail is located is the district responsible for providing FAPE. And when a student's in a facility operated by the Department of Corrections, then the Department of Corrections is its own LEA, and they are responsible for providing FAPE to the student. So it depends on kind of where the student is, but you want to know sort of who's responsible for FAPE, make sure they get the records that they need, and make sure that there's not an interruption of services to that student. OSIP further stated, and I thought this was interesting, I guess given the environment, but they said that the least restrictive environment provisions also apply to students in correctional facilities, and that IEP teams have to make still individual placement decisions. They have to be individualized, and they cannot routinely place all students in these correctional facilities in a special education classroom. So you can't have this segregation for special education students be sort of the norm. It has to be individualized and determined whether or not that's appropriate for a particular student. And then finally, I just wanted to mention that OSIP emphasizes that all of the due process protections under IDEA extend to students and their parents. Parents are still required members of the IEP team. They are entitled to all notices required under IDEA, and they must be afforded an opportunity to participate in the IEP team meeting. So none of that goes away when their child's in a correctional facility. Okay, so that's what's covered, but it's a long letter, and I would encourage you to read it. There's a lot in it. And then OSIP also issued another Dear Colleague letter this year. And this addresses the responsibility of school districts for meeting the communication needs of students with hearing, vision, or speech disabilities so that they can fully participate in school activities. And I thought they did actually a particularly nice job in this letter of explaining the obligations under Title II of the Americans with Disabilities Act, and then the interplay with IDEA. So again, if that's something that you're interested in, I would encourage you to read it. Title II requires school districts to ensure that communication with students with hearing, vision, or speech disabilities is as effective as communication with students without disabilities. And it's kind of a non-discriminatory analysis that students with these disabilities have to be able to fully participate like other students. So they have to have as effective communication as the other students. So that's where Title II is coming from. And so to do this, Title II says, school districts must provide appropriate auxiliary aids and services when necessary to provide effective communication. Now these may include qualified interpreters, note takers, real-time computer-aided transcription services, assisted listening devices, braille materials, large print, etc. So it can be a wide range of different types of services. Title II further requires school districts to give primary consideration to the aid or service requested by the student with a disability. So they're supposed to first give primary consideration to what the student says that they need. The school district must honor the choice of the student unless the school district can demonstrate that the one it's proposing, the alternative one, provides communication that is as effective as that provided to students without disabilities. So they have to give primary consideration to the one asked by the student or an appropriate family member. And they have to provide it unless there's another one that's going to provide that as effective communication. For many students, the special education related services and supplementary aids and services provided for an IEP will meet the Title II requirements. So you have the IEP, you put this in the IEP, it meets those Title II requirements. However, I think it's important to remember that Title II and IDEA are independent requirements. And while many students will have an IEP, Title II does not require IDEA eligibility. So you can have a student that needs these services through Title II and may not need an IEP through IDEA. So that's just something to keep in mind. And again, that's a good letter to look at. And then the last OSUP letter that I want to talk about involves the IDEA complaint process. So anyone may file an IDEA complaint with the Department of Public Instruction if they believe that either state or federal special education law has been violated. The complaint has to be signed, and the actions complained of must have occurred within 1 year of the filing of the complaint. The letter addresses a question of who bears the burden of proof in filing the complaint. So who has to show that what they say is the correct version of events? Okay, that's the burden of proof. And OSUP clarifies in the letter that neither party, when they file a complaint, has this burden of proof. Rather, the department has to conduct an independent investigation, review the information, and then make its decision. So neither party sort of has to prove their case. Rather, it's the department looking at the information and then making that decision. We have always followed that practice in Wisconsin. Apparently, there was some confusion about that in other states, so OSUP did clarify it. OSUP also said that, and I think this is important to note too, that the IDEA complaint process is a much less formal and less adversarial process, and that's certainly how the department views it than the due process hearing system. Okay, so when a complaint is filed, it is really meant to sort of resolve issues and move parties forward, and the department attempts to make it as least adversarial as possible. Okay, so speaking of IDEA complaints, I'm going to turn to IDEA complaints now that have been issued in this school year. And the first topic that I want to address is special education evaluations. We continue to get these every year, and so I always think it's good to remind people that in Wisconsin, when a special education referral is made, the district has to move forward with that evaluation. There's no sort of independent determination as to whether the referral is warranted. Okay, so in Wisconsin, when you make a special education referral, the district has to move forward with it. Referrals have to be in writing. They have to include the name of the child, and they have to explain why the person believes that the child is a child with a disability. If a parent informs a district staff member that they would like a special education evaluation, but they haven't put it in writing, the district has to inform them of the requirements for making a referral. So they have an affirmative obligation to explain that they have to put it in writing, they have to give the name of the child and the reasons why they believe that their child's a child with a disability. So we have two cases that talk about special education evaluations kind of around these requirements. In the first case, what happened is in November, the parent expressed concerns to a district staff member about her child's academic progress and stated that she wanted to refer her child for a special education evaluation. So she talked with the staff member, and the staff member explained to her how to make a referral process, so they met that requirement. And then the staff member also talked to her about, we can try some interventions in the regular education classroom first and, see how that goes. We don't have to do an evaluation right now. And the parent agreed that that was a good idea. And that's okay. So if somebody makes a referral and the district talks to that person and they agree that, yeah, there's some things that can be done first, let's do those things first and see how it works, that's perfectly appropriate. So they don't have to move forward with it in that case if there's agreement. Okay. But then in documenting the decision, so they agreed that they weren't going to go forward at that point, the paperwork that the district used said the parent agreed that the referral would be denied to allow time to implement an intensive intervention, and that once a sufficient amount of data was collected, the school team would determine the most appropriate option for the student. So that was the problem in this complaint, because the way the paperwork was filled out indicated that the school district could independently determine whether an evaluation was warranted. And as I said, there's no sort of gatekeeping way in Wisconsin that if a parent wants to make a referral and wants to move forward with it, the district has to move forward with that evaluation. So that was the problem in that case. It was really more about how that form was filled out than the actions themselves that the district did. Okay. So the next case, I think, is an interesting case because it talks about affirmative obligations that districts have to make referrals as well. So in this case, the student was a high school student who had been in high school for about 2 years in the district, so they were sophomore. During that time, the student was hospitalized for mental health issues, and district staff were aware of this and had consulted with the hospital staff. The student also struggled academically, was doing very poorly, failing the majority of her classes, was frequently absent because of the mental health issues, as well as she was seeking some treatment during the day, and then was involved in several behavioral incidents resulting in suspensions and eventually a move for an expulsion. That was dropped, but there was several behavioral incidents. The counselor met weekly with the student and was aware that the student was struggling and had these issues. The parent met with school staff during this time, and the parent did ask for accommodations, but the staff never explained to the parent how to make a special education referral or how to even make a 504 referral. So the information was not explained to the parent. Eventually, the parent enrolled the child in another district. That district evaluated the student, and the student was identified as a child with a disability. So what the department found in looking at sort of the facts of this case and looking at the issues is, for one thing, staff had not received training on special education referral processes in the last 3 years. So it certainly wasn't recent, and because of staff turnover, some staff members had never received training. And under state law, a district has to provide information and in-service opportunities to staff so that they know how to explain to the parent what the special education procedures are for evaluating a child. The district also found that the parent was never informed of her right to make a referral. But finally, and this is a unique case, the department found that based on the facts in the particular case, the district had an independent obligation to refer the student for a special education evaluation. We found that given the combination of factors, the absences, the hospitalization, the mental health issues, the failing grades, and the behavioral issues, that triggered this affirmative action on part of the district. And I think what this case shows is that, particularly with mental health issues, that might not be apparent in the early years, but they become more problematic and more apparent in high school years. And I think elementary staff are very attuned for looking for children that might be a child with a disability and are more aware of special education evaluation procedures, but high school staff might not be. And so I think that this case highlights sort of the need to make sure that high school staff members are aware of the need that some children might have for a special education evaluation, as well as how to inform parents of their rights and how to make an evaluation. So I think that that's sort of what this case, I think, stands for and is a good example. So the next couple discussions or cases I want to discuss involve obligations to hold an IEP team meeting. So in the first case, the parent requested an IEP team meeting in October to discuss her child's sensory needs. When she made this request, the staff member said, I think you can talk to the OT and that should be sufficient. I think you can express your concerns and that should take care of it. I don't think we really need to have an IEP team meeting. And the parent agreed. So that was okay. Again, this is an example of the parent agrees that her concerns can be addressed by just talking to the OT, and they don't need to have an IEP team meeting. However, then in early November, the parent requested an IEP team meeting because her child was running from the classroom frequently, and so she wanted to discuss his behavioral incidents, and then she also was concerned about annual progress on the goals, so she wanted to review those and talk about that. So that was in early November. The parent repeated the request in late November, and the district had trouble scheduling it. Now, part of that was because the parent was bringing an advocate, so coordinating all the schedules. Part of it was staff schedules. Part of it was winter break. But eventually, the meeting was scheduled for on January 6th, and then there was a snow event, and so the meeting was canceled, and it wasn't held till January 16th. Now, there was a lot of things going on during that time, but the department found that more than 2 months was too long to delay in responding to a request for an IEPT meeting. I think in almost all cases, probably 2 months is going to be too long. But sort of what is the amount of time, what's a reasonable amount of time in conducting an IEPT meeting is going to depend on the facts of the case. And so, you have to look at them individually. There's no set time, but I think 2 months is pretty much always going to be too long. The other thing to note about this that I think it's important to remember is that a parent may request an IEPT meeting at any time, and the district has to respond to the parent by either conducting a timely meeting or providing written notice as to why the request is denied. And the district has to grant any reasonable request. So we found that in this case, it was just too long to wait until January. Okay, so the next case doesn't involve a parent request for an IEPT meeting so much as there was a need for an IEPT meeting. So again, it's an example of kind of the district's obligation to independently call for an IEPT meeting. So what happened in this case was in November, the student began having significant health issues and began missing a lot of school. By mid-December, the student had missed about 20 school days. By January, it was about 40. Okay, so this was a lot of days. In December, by mid-December, the district conducted their annual review of the IEP, and they found that the student had been missing a lot. They noted that. They noted that the absences were adversely affecting his academic performance, but they didn't address it in the IEP. So they didn't review it from that sort of angle and that perspective. What can we do to help this student while he's missing so much school? And then they didn't have an IEPT meeting then until the end of January. And at this point, he had missed 40 days of school until they had a meeting to address the absences. And we said that that was too long to wait. That when a student starts missing a lot of school, that there is an obligation for the district to hold an IEPT meeting to look at those absences and discuss how they can be addressed, because you want to make sure that the student continues to receive FAPE. So that's sort of the point of that case. Okay, so then the next case that comes up a lot has to do with supplementary aids and services and self-advocacy. So in the student's IEP, they provided modifications for tests in science and social studies. The modifications were that the student could have extra time to complete the test or have the test read to her, but it was up to the student to determine if they were needed. And what we said is that if a student needs a certain supplementary aid, that it must be provided in accordance with the IEP. So you can't leave it up to the student to say, oh, I want this now, I don't need it now. If it's in the IEP, it has to be provided. That's a service that the IEP team has determined that the child needs in order to receive FAPE. And self-advocacy skills are great, and you certainly want to encourage and help the student develop those, but they can be done through annual goals rather than the services. So you can have a self-advocacy goal for the student, but not in terms of asking for supports that they need. Okay. So the next case talks about transfer and ESY services, and that's 14-042. So as you probably know, when a student transfers between districts in Wisconsin, the new district, in consultation with the parent, must provide FAPE to the student, including services comparable to those described in the student's IEP from the previous district, until the new district either adopts the IEP or develops a new one. So in this case, close to the end of the school year, the student's parent ended open enrollment, and the student then transferred back to the resident district, treated as a transfer student. The IEP from the open enrolled district provided for ESY services. However, when the student transferred back to the resident school district, they did not provide ESY services, so those were missed. And what the department found is that the district, the resident district, had an obligation to provide those ESY services because those were the comparable services from the other school districts, so they had the obligation to continue to provide those. So what this case stands for is that, you know, ESY is part of FAPE for a student. So districts want to make sure that those ESY services are provided. That's different from summer school that is not determined to be what the child needs in order to receive FAPE. But if the child has ESY services in their IEP, then those do have to be provided. Okay. And then the next case, which is 15-014, if you're following the outline, involves a situation where the student's day was shortened. The school day was shortened, so we're going to talk a little bit about shortened days. And the department found that in this case, it was appropriate to do so. And I think this is a good example of a district sort of looking at some issues and then taking appropriate action to address the student's individual needs. So the general rule with shortened days, or the general rule in general, is that students with disabilities must attend school for the same number of hours and minutes as those students who are not disabled, unless the IEP team determines that based on the student's individual disability-related needs, that the child requires a different day, a shorter day. This should be done only in rare circumstances, so this shouldn't be a common thing, and it should always be based on a child's individual needs. The other thing to remember is that when a child's day is shortened, the reason for it has to be in the IEP, so there has to be an explanation as to why the IEP team is shortening the child's day, and there has to be a plan in place for bringing that student back to a full day. Okay, it can't be that they're just doing this and there's no plan in place. The plan, at a minimum, should include meeting more frequently to review student data to determine if the student is now able to return to a full-time day. And the other thing to keep in mind is that when a day is shortened, it should only be in terms of a few weeks or a few months, and certainly not a few years. Okay, this is not a permanent thing for, you know, I mean, again, if it was disability related, maybe, but 99.999% the child needs to be back in school on a full day in a pretty quick basis. So in this case, what happened, and again, this was an appropriate action for shortening the child's day. The student was attending a full-day treatment program, had significant mental health needs, and needed some intensive therapy at the beginning of the school day. District staff, and I thought this was really important, the communication that the district had throughout this whole time with the students' therapy providers was really significant and really helpful to the school district. So district staff met with the parent and with the providers from the day treatment program on a regular basis. But in the beginning of the year, they met, and the providers told the district that, you know, at this time, because of the child's significant mental health needs, he's really not able to access much education. We're really focusing on therapy, and the program was really focusing on therapy. He received a little bit of academics in the day treatment program, but most of it was therapy. So that they determined as a team, with input from the providers, that he would receive 1 hour a day of academics at the school, and then the rest of the time would be in the day treatment program receiving this therapy. And so they explained that in the IEP. It was incorporated in the IEP. And is equally important, there was a plan in place for bringing that child back to a full day. So the plan was that they were going to meet frequently, and they did. They met with the parent probably every couple weeks, and they met with the providers and the IEP team every month, okay, to review how the student was doing, how was the therapy going. And as the therapy needs of the student was reduced, then the day was lengthened. So throughout the school year, the student's day was continually lengthened as he was responding to the therapy and getting what he needs there. So, you know, again, this district did a lot right. And what they did was, you know, they had the reasons for the shortened day in the IEP. They based it on individualized disability-related needs of the student, and they saw this as a temporary situation. They were bringing him back as soon as he was able, and there was a plan in place for that. So that's kind of, shortened days are something to kind of be aware of the parameters around them and the requirements when a day is shortened, because again, it should really only be in a rare case. So the last IDEA complaint that I want to discuss is 14-046. And this case I also thought was timely because it has to do with a student that was graduating from with a regular high school diploma in June of 2014. But during the 2013-14 school year, the district did not conduct an annual review of the student's IEP that they were supposed to. They also didn't complete a summary of performance. And so those are things you want to make sure is done for the student. When a student graduates with a regular high school diploma or exceeds the age limit for special education eligibility, turns 21, the district is required to provide the student with a summary of the student's academic and functional performance, including recommendations on how to assist the student in meeting the student's post-secondary goals. So there should be academic achievement and functional performance information as well as recommendations in there. The summary of performance is not considered part of the IEP, so it doesn't have to be developed by the IEP team. I was recently asked if there was a time limit for completing it. How soon do they have to complete it before a child graduates? And there's not a time limit, but it has to be reasonable so that the child and the family does have notice and can prepare for the graduation. Okay. So then the last decision that I want to talk about is a due process decision. And this case I thought was particularly interesting because it addresses allegation of bullying and how that could impact FAPE. So I don't know if you remember, but maybe like a year or two ago, OSIP issued a letter on bullying. And in that letter, they said that when a child is bullied at school, that could adversely impact their ability to receive FAPE. And so when that happens, in addition to addressing the bullying, the school district has an obligation to conduct an IEP team meeting, review the IEP, and determine if additional services or different services are needed because of the bullying and because of this effect on the child's receiving FAPE. So that's kind of what the bulletin from OSIP said. So this is the first case I've seen in Wisconsin that they're applying an IDEA analysis to allegations of bullying. So the parent in the complaint alleged that bullying affected his child's ability to receive FAPE. And what the hearing officer found, there were several incidents that the parent alleged, but the hearing officer found that none of these incidents involved bullying. Rather, they were more either like misunderstandings or misinterpretation. So there's definitely, or disagreements, there's definitely some disagreements going on, but they weren't really bullying. So, for example, one of the incidents involved the physical education teacher telling the class in general that roller skating was canceled because a parent complained about it. Now, it happened to be the student's parent, but they didn't mention names. And again, the hearing officer didn't really feel that this was a bullying incident. And the district did respond. The FIA teacher actually sent the parents a letter of apology, and then the district reassigned a different staff member to work with the students. So, I mean, they addressed it, but the hearing officer didn't really think it was bullying. The other incident was that the student wanted to receive his support services in the library rather than the special education room. The district accommodated that, but the student didn't want the special education teacher while he was in the library with him, but that's what the IEP provided for. So the district informed the parents that if you want to change that, we need to look at the IEP and have a meeting. And so again, the hearing officer didn't really find that to be a bullying incident. And the other ones were similar to that. So I think what's important about this case, even though they didn't find that there was any bullying that was affecting the child's ability to receive FAPE, is that it's out there and that this, the hearing officer did analyze it under this sort of analysis. And so I think that it suggests that the guidance from OSUP is being applied in Wisconsin by our hearing officers. Okay, and then I just want to cover some resources that the department has developed this year. We have 2 bulletins out that are fairly recent. One is on manifestation determination. The other is on shortened days. The bulletin on manifestation determinations explains like when's one required, the criteria for determining whether or not conduct is a manifestation of the child's disability, who must be there in making this determination, and what information has to be considered. So it's a pretty comprehensive bulletin around that subject. The bulletin on shortened days discusses the parameters around shortening a school's day and explains what information has to be included in the IEP, like I talked about with that case. I also wanted to just let you know that the department also has bulletins on other topics that I discussed today. We do have a bulletin on extended school year services. We have one on describing special education services in the IEP. All of these bulletins are posted on our website, and the quickest way to get to them is if you go to the index, which is on top of the special education team page, click on that and click on bulletins, and you'll see the whole list of all the bulletins that we've been developed. So I thank you for your attention, and I think that's it.